Good afternoon, everybody, and welcome to the investiture of Heidi Hurd as the Ross and Helen Workman Chair in Law. It's heartening to see such a large contingent of Professor Hurd's colleagues, students, family, and friends here to celebrate and indeed to be a part of this noteworthy occasion. Investitures are a venerable tradition in academia, a way to acknowledge and honor faculty members who, over the course of their careers, have demonstrated exemplary achievement in their scholarship, teaching, and public engagement. Investiture as a named chair, which we have before us today, honors a particularly rarefied academic accomplishment. Although Illinois did not thus invent investitures, I think we here make them a centerpiece of our school's intellectual life better than any other place with which I'm familiar. And I actually think Heidi, when she served as Dean of the College of Law, was largely responsible for that, just one of the many things for which we owe her tremendous gratitude. In addition to celebrating our honorees and their family and friends, investitures provide an opportunity, of course, to honor donors whose vision and generosity make events such as this one possible. The Ross and Helen Workman Chair in Law was created through a generous estate gift from esteemed alumnus, supporter, and friend Ross Workman and his wife Helen. They established the chair to sustain faculty excellence in research and in teaching. As Ross put it, quote, "Helen and I have always been interested in the quality of academics. We believe that the future of the country relies on the quality of education of its young people. I likewise feel strongly that we should do our part to maintain the excellence of the College of Law." A 1949 graduate of this law school and a 1947 graduate of the now Geese College of Business here on campus, Ross became a lieutenant colonel in the JAG Reserves and then enjoyed a distinguished career at Allstate Insurance, retiring in 1982 as the Vice President of Real Estate and Construction. He was awarded the college's Distinguished Alumnus Award in 1982. We are profoundly grateful to Ross and Helen for the legacy they bestowed upon the College of Law, including but not limited to this wonderful chair that they endowed. Today we are joined by a distinguished campus leader, Dr. Andreas Cangelaris, Vice Chancellor for Academic Affairs and Provost, and the M.E. Van Valkenburg Professor in Electrical and Computer Engineering. As the Chief Academic Officer for the Urbana-Champaign campus, Dr. Cangelaris helps set our intellectual tone and oversees all of the campus's academic programs, policies, and priorities, which are designed to ensure a superb educational experience for students and to sustain scholarly accomplishment through free, wide-ranging, and ambitious inquiry, intellectual rigor, as well as diversity and inclusion. Dr. Cangelaris has been on the University of Illinois faculty for over 2 decades now, since 1997, specializing in the area of theoretical and applied electromagnetism, with special focus on the advancement of modeling methodologies and computer-aided design tools for analysis, and noise-aware design of high-frequency, high-speed integrated electronic systems. On these subjects, he has authored or co-authored more than 250 refereed papers and articles in journals and conference proceedings. Dr. Cangelaris' teaching interests and activities include undergraduate and graduate level courses in electromagnetic wave theory and its engineering applications. From 2013 until late last year, when he was named Vice Chancellor for Academic Affairs and Provost, Dr. Cangelaris served as Dean of our College of Engineering, and prior to that, he was the head of the Department of Electrical and Computer Engineering within that college. He was named the M.E. Van Valkenburg Professor in Electrical and Computer Engineering in 2007. His tenure on this campus also includes a 2-year appointment as an Associate Provost Fellow from 2006 to 2008, during which time he led the activities of a campus-wide committee to review and update the campus's promotion and tenure procedures. Please join me in welcoming Andreas Cangelaris.
Thank you very much, Vic, and Good afternoon to all of you. It really is a pleasure and a privilege to represent the campus today as Professor Heidi Hurd is named the Ross and Helen Workman Chair in Law. It was mentioned that I was Associate Provost Fellow for a couple of years, and it was at that time that I had the opportunity to meet with Professor Hurd for the first time in her role as Dean. On behalf of Chancellor Jones, I would like to congratulate Professor Hurd on this wonderful achievement. I would also like to welcome everyone to this afternoon ceremony, especially Professor Hurd's family, friends, and colleagues. Investitures are events that celebrate our faculty excellence, and through it, our stature as one of the most influential universities in the nation and the world. To hold such a named position is the highest honor a university can bestow on a faculty member. So we reserve this honor for those who have truly distinguished themselves as influential scholars, innovators, and leaders. We have been fortunate to have a long history of investiture on our campus, thanks to our generous benefactors and loyal alumni who recognize the importance of faculty excellence. We are grateful to them for their support and for their invaluable contribution to attracting and retaining highly accomplished scholars such as Professor Hurd. We have approximately 260 named and endowed faculty members across campus in a variety of disciplines, departments, and colleges. Our named faculty members are part of an elite group. Many of them have gone on to become university presidents, chancellors, and provosts. They have achieved some of the highest honors in academia and beyond, including the Nobel Prize, the Pulitzer Prize, and the National Medals of Science and Technology. They have earned countless other national and international honors, have been awarded honorary degrees from leading institutions, and are members of distinguished organizations in their disciplines as well as the national academies. In the nearly 90 years that the Illinois campus has recognized faculty with named positions, all the recipients have embodied common characteristics valued by our institution. They have extremely high standards of excellence, extremely high expectations. They are disciplined and dedicated researchers. They have been nationally and internationally recognized as leaders within their fields and disciplines. They have been devoted educators of our students, mentors and confidants to our junior faculty. Professor Hurd, today's ceremony celebrates a significant milestone in your career. A career distinguished through excellence in teaching, world-renowned scholarship in law and philosophy, and academic leadership, which includes your service as dean of this very college. You exemplify the high standards and expectations this college sets out for every faculty member who chooses to join this community. Professor Hurd, it is a great honor to have you as a faculty colleague. We are proud to count you among our most distinguished faculty members and look forward to your continuing scholarly success. Congratulations on this latest and most deserving addition to a career full of honors and awards.
And now a little bit more about the person we're honoring today. Professor Hurd joined the College of Law in 2002 as its 11th dean and held the David C. Baum Professorship in Law from that year until she was bestowed the honor we are recognizing here today. She's a scholar and teacher in the areas of criminal law, torts, environmental law, environmental ethics, and the moral, legal, and political philosophy. Heidi has had already such an amazingly rich and diverse career in the academy, and yet one still gets the sense that she's just getting started. She spent her first 12 years as a professor at the University of Pennsylvania, where she was an assistant associate and then full professor of law and philosophy, where she also served as associate dean for academic affairs and as the co-founder and director of the University of Pennsylvania Institute for law and philosophy. While at Penn, she was also a visiting professor at the University of Virginia Law School. I was just there last week, and people were still remembering your time there fondly. And the University of Iowa Philosophy Department, and spent several summers teaching law and political theory in Hungary, Germany, and Ukraine. Before joining the faculty at the College of Law, Professor Hurd was also the Herzog Research Professor of Law and co-director of the Institute for Law and Philosophy at the University of San Diego Law School. Since coming to Illinois, she has held 3 separate six-month visiting research fellowships at the Austrian National University in Canberra, Australia, and she has taught in the Soros Foundation seminar series that has alternated between the Ukraine and the cities of Moscow and St. Petersburg in Russia. She's also been a visiting professor at Georgetown University's McDonough School of Business, at the University of Alabama School of Law, the University of Tel Aviv School of Law, the Uganda Christian University School of Law, and the University of Erlangen-Nuremberg Program for American Studies. In August of this year, she will be a visiting professor at the FGV Direito Sao Paulo School of Law in Brazil, where she will teach comparative environmental law. She is a lifetime member of the Academic Advisory Council of the Torquato de Tia University in Buenos Aires, Argentina. She is the author of a Cambridge University Press book, Moral Combat, and she has solo-edited collections of essays forthcoming from Cambridge University Press entitled Moral Puzzles and Legal Complexities, Essays on the Influence of Larry Alexander. With Ralph Brubaker, she has a contract with Oxford University Press for a book on the moral underpinnings of personal bankruptcy entitled The Virtue of Bankruptcy. She has written numerous anthologized book chapters, peer-reviewed philosophical essays, and articles that have appeared in the nation's top journals, including the Yale Law Journal, the Stanford Law Review, University of Pennsylvania Law Review, Michigan Law Review, University of Chicago Legal Forum, Law and Philosophy, and Legal Theory, among many, many others. She's given over 150 lectures and paper presentations across the United States, Canada, the United Kingdom, Europe, Central America, and South America, as well as in universities in the Middle East, Africa, East Asia, and Australia. On top of that, she has found time to provide testimony before our own U.S. Congress in D.C. on various proposed criminal legislation. Professor Hurd received her bachelor's degree from Queen's University in Canada and a master's in philosophy from Dalhousie University, which I think is in Nova Scotia in Canada, and a JD and a PhD in philosophy from the University of Southern California. In 2016-17, Professor Hurd returned for a mid-career master's in environmental management at the Yale School of Forestry and Environmental Studies. As one of her colleagues remarked, Heidi is a precise and systematic scholar with an ability to cross into different doctrinal areas, unravel complexities, and offer new insights. Another added, quote, although highly philosophical, Heidi's work has been extremely relevant. I like that contradistinction. Although highly philosophical, Heidi's work has been extremely relevant and on the cutting edge of contemporary public policy debates. Yet another observed, quote, beyond Heidi's particular works of scholarship, she is a powerhouse in the field generally. She is an institution builder. In fact, the Institutes of Law and Philosophy at Penn, San Diego, and Illinois are examples of her drive to create communities of scholarly discourse. The thriving discourse in law and philosophy at American law schools is, in significant part, directly attributable to all that she has constructed. One luminary cut to the chase by declaring, I consider Professor Hurd one of the preeminent legal scholars of her generation. Another, confirming this assessment, added, I regularly teach her papers, several of which are classics in the field. I particularly liked personally what one reviewer said in observing that, quote, it is impossible to read anything Heidi writes without learning and being challenged. Her students are similarly enthusiastic. They describe her as energetic, brilliant, and helpful, and, quote, an outstanding and knowledgeable and truly beloved professor. She is extremely personable and shows a lot of respect and care towards her student, end quote. One student characterized her as, quote, incredibly entertaining and interesting with a real passion and talent for teaching. Another, with the brevity and informality of a tweet, summarized, Hurd rocks. Many, many others not only praised her, but expressed their heartfelt gratitude to her. As one put it, quote, thank you, Professor Hurd, for always remaining animated and excited about tort law. Your passion engaged the class and kept our minds thinking. Perhaps the most thought-provoking comment was from a student who said, glad this class made me see environmental law as a legitimate, tangible subject and not some hippie concept. So you got through to that one. In a somewhat related vein, how about this? Great teacher, but very philosophical. I hate philosophy. So there's only so much you can do. Even the great ones can't reach everybody, Heidi. On a personal note, I really want to say that when I came into this institution a few years ago as a dean from the outside, Heidi, in her capacity as a former dean, could not have been more giving and gracious in offering me help when I asked for it, but also in allowing me to find my own way when I needed to. From one dean to another, Heidi, thank you very much. A first-rate scholar, a dedicated and transformative teacher, and a generous colleague, Heidi, it is my privilege today to help recognize your many accomplishments by conferring upon you this honor that you so richly deserve. If you would be so kind as to stand, I can present you with this medallion marking your formal investiture as the Ross and Helen Workman Chair in Law.
Goodness. Wow. Wow, wow. Thank you, thank you, thank you. Oh, my goodness. Heavens. Oh, thank you all. Oh, my goodness. Thank you, Provost Kangalaris and Dean Amar, for those incredibly generous introductions. I'm absolutely thrilled that my family might actually believe them. And thanks to everyone who's taken an hour out of a very busy day to join in this gathering. I'm very touched, I'm very honored. I'm just incredibly appreciative. And I want to begin by thanking Carrie Mae Borch and Heather Ball and Carolyn Turner for orchestrating this very flattering event, with a special shout out to Carrie. Their classy efficiency, as I call it, is emblematic of the college's very talented administrative staff, who are all too rarely thanked for their tireless work on behalf of faculty like me and students. I have been lavished today by the attendance of a great many dear ones who've come from near and from far, many from afar, and it would take me all the time I have to say even a few words about each of them. So with apologies to all of them, I'm going to introduce just those who traveled from out of town to be here, and I'm going to resist the temptation to give them the enthusiastic descriptions that they deserve. So my mother, Jean Hurd, is here only in smiling spirit because she passed away in 2013. But my dad, my 91-year-old father, sitting right here in front, traveled from Wyoming to be here. My dad's a PhD political theorist and lawyer whose lifelong passion for holding the law and legal institutions responsible for advancing justice has had a profound influence on my career, and nothing could make me happier than to see him sitting right here in the front row. My brother Markham Hurd over there, give away as Hansel, known to me as Hansel. You got to appreciate the humor of our mother who had children and she named them Heidi and Hansel. Took a red-eye flight from Seattle to be here today, so that's going to cost me a lot of wet willies. And I'm also delighted that 3 of our 4 children are able to be here. My wonderful stepdaughter, Samantha, flew out from Silicon Valley, where she is a global vice president with ABB. My son, Aiden, sitting right down here, is from South Carolina, where he's a junior at Furman University, and I am delighted that he was able to bring his lovely partner, Natalia Baldwin, with him. And my daughter, Jillian, sitting over there in the middle, flew in from England with her British beau, Chris Bache. Jillian is a junior at the University of Chicago, but she's spending this year studying philosophy at Cambridge University. My two very dear uncles came for this occasion on both sides of the family, sitting right in the middle. My Uncle Donnie Hurd from Higginsville, Missouri, and my Uncle David Lamall, known to the family as Jazz, from Norwich, Vermont. And I'm tickled that a number of cousins from both sides of my family came from far and wide to be here today. Paula Robinson from Odessa, Missouri, Anne Marie and Scott Brown from Worcester, Ohio, and Corinne and Tessa Danielson and Andrea Speza from West Palm Beach, Florida. And now, as to friends, I'm promptly going to start my introduction of just a few friends in the room by breaking my rule against introducing local friends, because I want to make one special exception, and that is for Terry and Judy Iverson, sitting right here in the middle, and this is why. Terry Iverson met me when I was less than a year old. He was an undergraduate student in my father's 1961 American government class when my dad was an assistant professor at the University of Wyoming. And so I just want all my 1L Crim Law students to reflect on the significance of Terry's being here, because I fully expect all of you to be at a significant event of my children 30 or 40 or 50 years from now. My best friend, Laurel Zeski, from law school, came out from Orange County, California. We met in the first 2 minutes of orientation back in August of 1980, and we've been great friends ever since. Larry Solem, who's both a dear friend to me and a great friend of the College of Law, honors us all with a return to Illinois from Georgetown University. Jeff Coates, sitting right out there, was once the Assistant Dean of Development here at the college, and he's now Associate Vice President for Advancement at the University of Central Florida in Orlando. My dear friends, Jim and Beth Baranski and John Bookless, drove down from Galena, Illinois. Bob and Kathleen Murphy came down from Chicago, and Janet Ruckman and Lindsay Delaney came all the way from Monticello, Illinois. So when I count my blessings, I count all of these dear friends and family members who are crazy enough to travel long distances to be here for this 1 hour. And I also count my many local friends who are in the room today, who I haven't had a chance to introduce, but you all know who you are, and I'm very honored that you've come today to share in this event. And finally, I want to thank two people who make my world go round. The first is my wonderful College of Law assistant, Jackie Hadler, who is uncannily like radar in MASH, because she can read my mind before I've even made it up, and she is well on her way to acting on my best intentions well before I formed them. I simply couldn't do the work I do without Jackie. And then there's my sweetie, Michael Moore, who is every bit as kind and supportive and protective and loving as a husband as he is a jubilantly ferocious intellectual sparring partner in classrooms, in faculty workshops, in the car, over coffee in bed in the morning, over the dinner table. Michael has made the last 32 years of my life a grand adventure, and I love him to the moon and back. So I'm particularly thrilled to be invested today in the Ross and Helen Workman Chair, because Ross and Helen were great friends of mine. And this chair came to the College of Law when I was up in the head office, and I have very warm memories of the big alumni event in Chicago at which Jeff Coates and I and the Chancellor, right, got to announce this very exciting gift. But my warmest memory of Ross Workman goes back to the very first weekend after our move to Illinois. We'd first arrived in Champaign in the fall of 2002, and with the start of a new year, things were just frenetic, and I didn't know what I was doing. Andy Leopold can tell you that. He was the associate dean, and, you know, he was trying to steer me in the right direction, and I'd go off the cliff. Squirrel, squirrel. So I got up very early on the very first Saturday morning that we moved here, and I came into the dean's suite to unpack the enormous pile of boxes that had been delivered, and I wore the grubbiest of clothes, these ratty jeans and a torn T-shirt and running shoes and no makeup. And about an hour into the disaster zone that I was creating, in walks this very stern man in high feather. I mean, he's got, you know, pinstripe suit, and he's polished his shoes to mirrors, and he strode over to me, and he shook my very grubby hand, and he looked me up and down with a very disapproving frown. And he announced that his name was Ross Workman, and he needed me to sit down because he needed to tell me some things. And so then he sat and he lectured me about the importance of scholarship and the need to ensure that the college's stature as a locus of cutting-edge ideas was well known to the larger legal academy. And I figured that if the alumni were going to lecture the dean about the need for scholarly excellence, rather than the other way around, I had come to the right place. And I had. Because the Illinois College of Law is a remarkable brain trust with brilliantly ambitious faculty who, to a person, share Ross's conviction that the advancement of knowledge is the calling of a great law school. I am very proud to have as colleagues every one of my fellow faculty members in this room, and I hold every one of them very dear, even the ones who don't know it, even the ones who might not believe it. And we, as a faculty, are tremendously lucky to have Dean Amar at the helm, bringing the sort of vision and energy and commitment to excellence that Ross Workman so championed. Deans never get an appreciation that matches the 24/7 investment. And so I'd really like to invite you all to join me in taking this moment to thank our very talented and very dedicated Dean. So today I want to honor Ross Workman's ambitious aspirations for the chair that he gave by giving you my unique answer to a question that's been asked at least twice in the last few investitures. Why do scholarship? Why give one's life over to such a lonely pursuit? Several investitures ago, my colleague Bob Lawless asked this question, and he concluded that his calling is to test the law's empirical assumptions about the psychology of those whose incentives it trades on. And just a few weeks ago, my colleague Suja Thomas asked this question, and she concluded that her scholarly purpose is to shine a bright light on practices that chip away at guarantees of procedural justice. So my answer is this. I look for topics that reflect a convergence of two factors. First, I look for areas of law in which doctrinal confusions appear to reflect deep moral conflict that put the very purpose of the law in doubt. Areas in which the problems are not a product of invalid empirical assumptions or of imperfect legal processes, but rather reflect a kind of moral schizophrenia in which incompatible ideals are doing battle for the very soul of the law. And second, I look to see how likely it is that courts or agencies or legislatures will resolve these contests by backing what I take to be the wrong contestant, by, for example, sacrificing the interests of future generations in order to license the gluttony of the present generation, as happens depressingly often in environmental law, or by making scapegoats of defendants rather than treating them as they deserve, as tough-on-crime enthusiasts have achieved through doctrinal manipulations of the criminal law, or by ignoring the demands of corrective justice and instead devoting tort law to the bloodless task of efficient wealth preservation. But one area that well displays the relationship between philosophical ambivalence and doctrinal inconsistency, and that strongly suggests that the law is in danger of assuming the moral low ground rather than the moral high ground, is the area of animal law, or more accurately, the area of criminal law that concerns itself with animal cruelty. Now, for a lot of years, there's been something of a campaign by my family members and by friends and by students to get me engage with this topic. My daughter Jillian and my cousin Anne-Marie continue to inspire my vegetarianism, and they catch me when I start to drift. My student Grace McCartan persistently baits me to teach animal law. My Uncle Jazz sends me books on animal cognition. And my Uncle Don shares endless photos of pigs, little miniature pigs, in an effort to get me to adopt one so that we can work out a time-sharing arrangement. So by way of both complementing their persuasiveness and illustrating the kinds of legal problems that speak to me as a legal philosopher, I want to take you through the ways in which animal cruelty laws reflect doctrinal inconsistencies that can only be resolved by settling fundamental philosophical questions about the moral considerability of animals. So this one's for Uncle Donnie. So prohibitions of animal cruelty were first enacted in the 19th century, but it took until 2014 for all states to make felonies of at least some forms of animal cruelty. But unlike most criminal laws, laws against murder and rape and kidnapping and domestic abuse, the purposes of which are uncontested, animal cruelty laws exhibit deep uncertainties about their very purpose, about who the real victim is when animals are treated cruelly, and about why animal cruelty constitutes a wrong to that victim. So consider the most basic definitions at work in these laws. What, for example, is the definition of an animal? Well, there are almost as many answers as there are code provisions. So Georgia, for instance, excludes from its definition of animal any pest eligible for extermination or removal from a business, residence, or structure. And Texas excludes from its definition any creature that has not been domesticated or at least captured. So in other words, it simply isn't possible to be cruel to a mouse that's caught in a house in Georgia or Texas, because house mice are not animals. They can be dismembered, microwaved, skinned alive, or repeatedly electrocuted, and this will not count as even prima facie cruelty in these states. But now pet mice. Pet mice are different in Georgia and Texas. If someone dismembers, microwaves, skins alive, or repeatedly electrocutes a white mouse bought at PetSmart, well, now that's a crime and potentially a felony, because animals that are conventionally considered pets are animals to whom one can be cruel in these states. And then one has to ask, how can members of the same species be animals and not animals? How can the intentional infliction of pain on one count as a felony, when on the other it counts as nothing at all? Or think about the fact that the majority of states, following the majority of countries, exempt fish from the category of animals protected by animal cruelty laws. So a Danish artist was exonerated when he set up an art installation at an elite gallery in which he had large goldfish swimming around in oversized blenders filled with water that were plugged into the wall. And visitors to the gallery were invited to turn on the blenders. And many did just that, with complete impunity. So right off the bat, you can see that animal cruelty laws lack a shared understanding of their very subject matter. Right? The variability across states in the definition of what counts as an animal does considerable work to create a national patchwork of laws that embody contradictory prohibitions and permissions. Now think about the definition of animal cruelty. So animal cruelty is very commonly defined as the unreasonable or unwarranted infliction of suffering. If we define domestic abuse as the unreasonable battery of a domestic partner, or if we defined rape as unwarranted non-consensual intercourse, we'd be saying that there's such a thing as reasonable domestic battery, such a thing as warranted sexual assault, and that when such acts are reasonable or warranted, they aren't in any way morally objectionable, and hence they're not even of prima facie legal concern. How preposterous would that be? But animal cruelty laws make clear that when animals suffer for reasonable ends, that suffering is not in any way morally problematic, and hence it's not even a prima facie legal concern. It's not that animal suffering of any sort is morally odious, and that it can only be justified by the prevention of an even greater moral wrong. It's that it isn't even prima facie problematic if it's deemed reasonable. Now, of course, the devil's in the details, right? Because if animal suffering is deemed reasonable only in circumstances in which the criminal law would otherwise accord perpetrators full-blown justifications, well, then animal cruelty laws would effectively allow the infliction of suffering on animals only when it would be justified by standard defenses in the criminal law. Self-defense, defense of others, true necessity. But of course, this is not the case. Because all sorts of activities that cause great pain and suffering to animals are thought to be reasonable. And most of these come nowhere close to being the moral equivalent of acts that save human lives or constitute the least harmful way of preventing greater moral evils to the community. So, for example, a great many practices cause animal suffering in the course of agricultural operations, but they're exempted from animal cruelty laws. So just take the notorious example of how veal is still produced in numerous facilities across the nation. The goal of veal production is pale, white, anemic meat. So the male calves that are birthed in dairies, which of course have no use for male calves, are fed a synthetic formula that lacks iron while being deprived of water in enclosures that are so warm that in their desperate need to cool themselves, they perpetually continue to drink the formula. They live their entire lives in wooden crates. Why? Because if their crates were made of metal, their craving for iron would cause them to lick the bars in ways that would pinken their flesh. They're so often tightly confined that they can't turn around or lick themselves or scratch themselves. Why? Not just because it guarantees soft muscles, but because if they could turn around, their desperate craving for iron would induce them to lick their own waste. And that would again pinken their meat. The formula they drink has a laxative effect, so the calves suffer from cramping and perpetual acidic diarrhea that creates searing open sores on their legs. So for these little guys, death can't come soon enough because their incredibly short lives are the definition of misery. And yet, this brutalizing treatment of veal calves is still deemed legally reasonable, legally warranted in 43 states in the nation. And so too are a great many other practices that would count as torture if done to a cat or a dog. Dehorning, tail docking, debeaking, branding, castration, ear notching, all without anesthesia, as well as the suffocating confinement that animals experience in concentrated animal feed operations. All of this counts as reasonable under most states' animal cruelty laws. And the same, of course, is true of numerous painful practices that are routine within rodeos and fairs and zoos and circuses and hunting and fishing and trapping and university research. All of these practices fall well short of being necessary in the sense that the criminal law standardly means that term. Because the notion of necessity in the criminal law always means more than that which is economically profitable or economically efficient or conducive to human entertainment or fashionable or in the service of human convenience or a time-saving means of reducing human irritation. So we can't think that what constitutes the reasonable infliction of suffering on animals coincides with our standard criminal law defenses, with what they would exonerate, with what those standard defenses would exonerate. So how are we to understand what makes the suffering of animals reasonable or unreasonable under our law? Well, a number of states have adopted Washington's practice of assigning panels of citizens and delegates of industry the task of determining what constitutes cruel treatment. But these panels are required to honor statutory exemptions for standard husbandry practices used in the commercial raising of livestock and poultry, for normal and usual animal treatment within rodeo events, for customary uses of animals in normal and usual events at fairs, for accepted animal husbandry practices in private animal custodianship, and for accepted veterinary practices. So in these states, panels are not entitled to rethink the legitimacy of practices that are standard, normal, usual, customary, accepted. What's ordinary is definitional of what's reasonable. And therefore, so long as animal industries don't innovate, so long as they don't break ranks, they insulate themselves from moral scrutiny and therefore from legal intervention. What other profession is so perfectly self-immunized from liability? I mean, we know that in other professions, what's customary is evidential of what's reasonable, but it's not its perfect measure. Yeah. Learned Hand famously insisted in the T.J. Cooper case. Whole industries can lag behind in the adoption of new practices, and what is ordinary and customary can come to be unreasonable in light of new technologies and changed values. There are precautions so imperative that even their universal disregard will not excuse their omission. So if the universal disregard of precautions can't insulate factories and railroads and coal mines and automobile manufacturers and fracking operations and airlines and shipping companies and tunnel builders from liability, what explains the willingness of the law to allow the universal disregard of animal suffering to insulate animal operations from legal consequences? Well, I want to suggest that a careful examination of the case law on animal cruelty reveals that there are at least 5 distinct moral agendas that are competing for dominance in this doctrinal arena. And I want to suggest that only when these are brought to light is it possible to start making sense of the law's contradictory efforts to protect animals. So let me take you through these quickly. On the first account, animal cruelty is a wrong not to animals, but to animal owners. So as a historical matter, this was decidedly true because the original purpose of animal cruelty laws was explicitly to protect the property rights of animal owners. So the very first animal cruelty law enacted in Vermont, for example, made it a crime to willfully and maliciously kill, maim, injure, or disfigure a member of an economically valuable species that belonged to another. So horses, cattle, sheep, and swine. So on this historical understanding, animal cruelty was just a species of theft or destruction of property. But you know, this understanding of animal cruelty is hardly anachronistic because it's the concern for animal owners, rather than animals themselves, that motivates the law to equate animal cruelty with unreasonable suffering, and then that equates reasonable suffering with what's profitable. If animal cruelty laws are fundamentally about protecting the property interests of humans, then unsurprisingly they'll permit whatever is deemed reasonable by owners of ranches and feedlots and dairies and CAFOs and rodeos and circuses and fairs and zoos, right? And then we have to pause and ask whether what counts as cruelty should turn on the market value of the creature who does the suffering. So on the second account, the gravamen of animal cruelty is it's an offense to public sensibilities. So in the language of one prominent Delaware attorney writing at the time that early animal cruelty laws were passed, while the brutes have no legal rights to inflict cruelty on animals in public, that injures the moral character of those who witness it and may therefore be treated as a crime. And it's a common theme even in today's case law. One sees courts worrying about how animal cruelty will impact on those in the larger public whose sensibilities will be offended or whose sympathies may become desensitized. So it's this concern that humans not lose their humanity in the course of exploiting animals that appears to make sense of why the law prohibits, public displays of bear wrestling and kangaroo boxing and dog fighting and cockfighting, even when the owners of these animals consent. And it's this account that best makes sense of why numerous states have followed Illinois in adopting prohibitions analogous to child pornography laws that punish those who create, sell, market, or simply possess images of animal cruelty. But it's also this notion that animal cruelty is problematic when and because it's a spectacle that makes sense of why the law leaves untouched practices that are conventionally accepted by industry practitioners who are living proof that these practices are not character corroding. And it's this notion that makes sense of why the law leaves untouched practices that are out of sight, out of mind. Practices that go on behind the closed doors of puppy mills and pig farms, poultry barns, veal operations, dairies, and pelt producers. And then we have to pause and ask again whether what counts as cruelty should really turn on the size of the crowd that witnesses an animal's suffering. So on the third account, the problem with animal cruelty is that it's a harm to those who share emotional bonds with the animal and who are personally pained by its suffering. And you can see this concern at work in the case of People v. Garcia that figures in every animal law casebook. So in that case, a father threw his son's goldfish bowl across the room and then forced his 9-year-old son to watch him stomp on the goldfish as it flopped on the carpet. And what moved the court in the father's subsequent prosecution for aggravated animal cruelty was not the plight of the goldfish, but rather the plight of the boy who lost the fish. It was on the basis that the boy suffered, rather than on the basis that the fish suffered, that the court found the father guilty, not of child abuse, of animal cruelty. Now, it's this concern for protecting the objects of human sentiment that appears to ground the distinctions at work in many states between harms done to domesticated animals and harms done to non-domesticated animals. Because in numerous states, it's a felony to abuse an animal that's conventionally considered a pet, with some states elevating penalties for harms done to dogs and cats in particular. While the very same acts of abuse, if perpetrated on non-domesticated animals, will count as misdemeanors at most. So in these states, it's a felony to cut off the paw of a pet rabbit, but not the paw of a trapped jackrabbit. It's a felony to use a hook and line to catch a goldfish in a tank, but not to catch the trout out in the stream. So animal cruelty on this model is a function of whether the animal that suffers is valued more for its human companionship than for its meat or its fur or its recreational value. Because what matters on this model is protecting those things that people love because they love them, because they want to live with them, right? And now we have to pause a third time and ask whether what counts as cruelty should turn on whether the suffering creature is deemed eligible to live in a house. Fourth model. On the fourth account, animal cruelty is a gateway crime that makes more likely future acts of violence against humans. So on this view, just as the illicit use of prescription OxyContin today is thought to be a gateway to the use of heroin tomorrow, so the slow dismemberment of rabbits today is thought to be a gateway to the torture of helpless children tomorrow. And there's some evidence that this is the case, because a number of the most famous serial killers bragged about animal torture. Jeffrey Dahmer, Son of Sam, Boston Strangler, Ted Bundy, and the 19-year-old school shooter in Florida last month had a record of animal torture. So on this model, animal cruelty laws are very much like other laws that prohibit acts prophylactically. The possession of firearms by ex-felons, the possession of burglary tools, the possession of counterfeiting technologies, the possession of drugs in quantities that indicate an intent to sell. Now, this rationale was very much at work in the infamous 1982 case of State v. Tweedy, in which the defendant placed a cat in a microwave oven in the cafeteria of his workplace, turned it on, and left the room. And the cat survived with just agonizing burns that it had to bear until it could be euthanized. And in its decision, the Rhode Island court emphasized its fear that if acts like this go unpunished, then perpetrators like Mr. Tweedy will escalate their use. In other words, it sought to punish Mr. Tweedy not because microwaving the cat was itself wrong, but because it evidenced a kind of inner depravity that could predictably result in violence against those for whom it would be a moral wrong. Now, if animal cruelty laws are fundamentally about preventing future violence to humans, then it's unsurprising that the cruelties inherent in hunting and fishing and rodeoing, I'm from Wyoming, I should be able to say that word, rodeoing, animal husbandry, and animal research are exempted, because nobody thinks that hunters and bronc busters and pig farmers and psychology professors are the next serial killers or school shooters. But now for the fourth time, we have to ask whether what counts as cruelty to animals today should be limited to what we fear will happen to animals tomorrow. On the fifth and final account, that can be teased out of the case law, we come to the view that animal cruelty constitutes a wrong to animals themselves. As Bentham wrote, because animals have the capacity to suffer, they have interests, preferences of a sort, welfare of a sort. And on any utilitarian theory, then, these interests have to be incorporated into cost-benefit calculations that determine what maximizes welfare. And on any rights theory, these interests may ground categorical duties on the part of humans not to cause animal suffering. So on this account, the victims of animal cruelty are animals themselves. The wrongs perpetrated through animal cruelty are wrongs to the animals themselves. But while this account is likely the one you thought I would extract from the case law first rather than last, this account is surprisingly dissonant with many of the doctrines that comprise these laws. Because if animal cruelty laws are fundamentally about protecting animals from suffering, then it's surely puzzling that we don't prima facie prohibit the infliction of all suffering on all creatures that can suffer. As laws against mayhem prima facie prohibit all forms of human disfigurement. As laws against battery prima facie prohibit all forms of non-consensual physical contact. As laws against theft prima facie prohibit all acts of dispossession. And it's puzzling that we don't limit justifications for acts that cause animal suffering to those that ordinarily exonerate defendants who commit prima facie infractions. Justifications that exempt those who save lives or who otherwise choose between evils so as to genuinely do what is necessary to protecting the greater good, as opposed to those who inflict suffering in the name of profit or entertainment or fashion or convenience or custom. And so you see, my family, my friends, and my students have been right. This is an area of law that begs for philosophical clarity, for the work of theorists who are dedicated to sorting out the demands of morality and to pressing for doctrinal reforms that will realize those demands without contradiction. And this is why I do scholarship. Because puzzles like these, they're what wake me up in the middle of the night. They're what motivate long hours in front of my computer screen. They're what energize my classes. So I am deeply grateful to Ross and Helen Workman for so generously investing in this, the life of the mind. And I am deeply beholden to the University of Illinois and to the College of Law and to my admired colleagues sitting in this room and elsewhere for providing me with an intellectual home in which I can pursue scholarly projects of the sort that speak to my soul. So thank you all very much, and thank you.
I think we all just witnessed what one of the reviewers I quoted earlier meant when he or she said, one cannot listen to Heidi without learning and without being challenged. And I don't know about you, but I also am always left wanting more. So I really hope you continue to pursue this because I'm having a difficult time figuring out what the right approach is. Given the framework that you so helpfully provided us. So thank you all. Thank you most of all, Heidi. Congratulations again on your achievements. And as is evidenced by your remarks today, we greatly look forward to your future accomplishments. So thanks again. Please, as we adjourn, join us for a reception in the Piers and Sarah Peterson Pavilion. And come back next time for another great event.